I call David Clendon.
Thank you, Mr Speaker. Mr Speaker, these two bills we're debating today are serious bills. They deal with serious issues of community safety, of reducing crime, reducing the potential for victimisation and re-victimisation of people. And I'm pleased to see that they've been debated in a serious matter, sort of appropriate to their gravity. So the previous speaker in his brief contribution did touch on one or two matters. We must seek to protect our communities, to put in place appropriate controls, legislation that does ensure, or at least to the greatest extent, ensure public safety, while also acknowledging that we are a country that commits itself to maintaining human rights, that respects civil rights. It would be unfortunate if we revert to the very dated language of soft on crime versus hard on crime. Let's adopt the notion of being smarter around crime and doing our very best collectively to get the best outcomes, the best solutions we can to assure a level of community safety. So these two bills, and we understand and support the notion of them being addressed as cognate bills to be debated together. They are so closely interwoven it would be difficult to do otherwise. They effectively establish two new regimes. The ESO bill, the extended supervision orders, obviously extend an existing regime. The public protection orders create a new regime. And we're in a position, sir, in the Greens where we perhaps not unusually, we support one of these bills, the Parole extended supervision order. We're happy to give our support to that, but we cannot support the public safety, public protection orders. For us, that latter bill simply goes a step too far. We believe that what it seeks to achieve can be achieved by other, less punitive and less onerous means, and that's in no way to not to acknowledge or recognise the seriousness of the offending and the difficulty of the offenders that will potentially be captured by that legislation. So as I said, the ESO bill does effectively allow for the possibility of extending the existing supervision order regime. There are undoubtedly Bill of Rights issues. It has been deemed by the Attorney-General to contravene the Bill of Rights, and that's something that often for the Greens would be a deal breaker. We take some comfort in this case, though, from the fact, firstly, that the courts will be intimately involved in making judgments about the imposition of these orders, that there will be mandatory review by the courts and indeed by the High Court, and that the Parole Board will also be obliged to review on a 2-yearly cycle, at least every 2 years, any of the so-called high impact conditions imposed on a person subject to these orders. High impact, for example, being anybody who's obliged to remain at one address for up to 70 hours a week, which is effectively a curfew, and that indeed clearly does put considerable constraints on an individual's freedom. And it's appropriate that when we're imposing these high impact conditions, that they are regularly reviewed and measured in the context of that person's behaviour, the possibility of them being able to earn the trust of the community within which they'll be living. I think, sir, that our greater, what influenced our decision even more on this was both personal interactions with people who are already subject to supervision orders and who with an admirable level of self-awareness recognise that they had no further supervision on them, that they would constitute a danger to the community and indeed to themselves. I've spoken, as have others, to individuals who are subject to, who are coming to the end of a 10-year supervision order, and they understand very well that they are not yet sufficiently trustworthy. If they were left to their own devices, if there was no mechanism in place to extend their supervision, they understand very well that there's a high likelihood they would reoffend, clearly would create victims, and ultimately would see those people back into prison. So the extension of the supervision orders we see as a middle road in a sense. It does allow for very high level supervision and monitoring of these people who have not yet earned the trust of the communities, and for very good reason, but it does not go that step into suggesting that either way, that they should be completely freed or put back into prison. There was some debate at select committee about whether these ought to be civil orders. Frankly, sir, we saw that as a debate about semantics in contrast with the public protection orders, whether they're civil or criminal in nature. We really need to look at the effect, both on the person subject to these orders and onto the effect of the likelihood of assuring community safety. With the points made in the feedback, the report back to the bill, about the importance of including some criteria for what constitutes behavioural characteristics, particularly of the violent offenders, because of course this legislation expands the scope from just child sex offenders through to those who have offended sexually against adults and to very high level violent offenders. And we think it's important that there is some criteria in that, some determination of actually what constitutes that level of behavioural characteristic that would make somebody eligible or liable to this quite dramatic, if you like, legislation. So in short, sir, we are supporting the Parole Extended Supervision Orders amendment because we do see that there's an existing need, and as I say, we have been persuaded to a large extent by actual interaction with the people who we know can, by their own admission, could not be safely left in the community unmonitored. So the Public Safety Protection Orders Bill we see is going a step too far. We think that the conditions that might have led us to think it was necessary to a large extent no longer apply. The fact that judges now do have access, for example, to preventative detention, and at a time where some of the people who might be subject to PPOs were given their determinate sentences, the preventative detention was not available. It's also true, of course, that some offenders are so young that they're not able to be subject to preventative detention, but nevertheless we believe that there are sufficient mechanisms in place, including, of course, this new legislation, the ESO legislation, that makes it unnecessary to go down this path of imposing these public protection orders. The Law Society, in its quite comprehensive submission to this, outlined some of the issues, and they determined that, in their view, this legislation does create an overly punitive regime for people who have been sentenced. They've been to court, a judge has imposed a sentence, and in most instances these people will have served their full sentences or been paroled, or some other mechanism will have been in place. The Law Society called for the bill to be either withdrawn or significantly modified, and we acknowledge there have been some changes made to the legislation, but really not sufficient that we could give it our support. This is undoubtedly a double jeopardy situation, an ongoing, almost a punishment without end, in a sense. There is possibility for these PPOs to be in order in place almost indefinitely, and we think that's inappropriate given that we do have other options available to us. Options including the range of sentencing and parole options for serious sexual and violent offenders. So I'll just quickly, in my last couple of moments, just make a comment about the context in which these debates are held. It's unfortunate, and I say this with no sort of righteousness. As a politician, I take responsibility as well. Very often these serious criminal bills they become effectively political footballs, and as I mentioned, we have this whole hard on crime, soft on crime nonsense. I think that we need to collectively endeavour to depoliticise some of these debates, to endeavour collectively simply to get the best outcome. I think we also need to address our friends in the media and endeavour to challenge the sensationalism that often surrounds reporting of serious offending. This latest instance, this unfortunate woman dubbed the Black Widow, who committed a serious crime. She murdered a person. But the sensationalism around the reporting of that case, the endless media gratuitous reporting, has now placed that woman in danger while she's serving her sentence. And I think Finland's a good case study where there was a political agreement not to politicise serious criminal legislation, and for the media not to sensationalise their reporting of crime and offending. And I think we could take a lesson from that. If we could get a similar level of agreement in New Zealand, I think we would find that the passage of this legislation would be much more refined and much more successful. Thank you, Mr. Speaker.